Just as the Nigerian government appeared to be making headway in upturning a $9.6 billion judgment debt granted in favour of process and industrial development in the UK, another multi-billion-dollar lawsuit against the federal government has come to light. The case involves an oil company, Petro Union, which instituted a $15 billion lawsuit against the government and Union Bank of Nigeria plc in 2012, alleging that it obtained a £2.56 billion cheque from Barclays Bank in the UK in 1994 and presented same to Union Bank in Lagos, but never got value for the cheque. The company is further alleging that Union Bank received the £2.56 billion and transferred £2.156 billion to the Central Bank of Nigeria, while retaining the sum of £396.8 million as commission. The amount was purportedly meant for the construction of 3 petrochemical refinery complexes in Nigeria. The lawsuit, which has moved all the way to Nigeria's Supreme Court, has, however, been mired in a dispute between the lawyers, Mr. Joe Kiari Gadzama, SAN, and Onyechi Egwonwu, said to be representing Petro Union. Despite appeals by the Justice of the Supreme Court and other lawyers to both men to settle their disagreement, Gadzama and Egwonwu have been at each other's throats over how to share a percentage of the judgment debt in the likely event that the case succeeds. Now here to deconstruct this complex case is Jude Igbanoi, Deputy Editor of The Lawyer, a weekly publication of This Day newspapers. Welcome to the show, Jude. Good morning.
Good morning. Thank you very much.
Jude, thank you very much for joining us. Well, let's start with the first letter of the IRA crew. What are the real issues in this case? Petro Union versus Union Bank, the federal government, and others. And how is this similar to the P&ID case?
Okay, the issues are quite complex, like she already mentioned. But in terms of similarity with the P&ID case, it is a judgment essentially against Nigeria, which has the potential of seriously adversely affecting the Nigerian economy if it's given, if it's executed. Although the P&ID case was gotten through an arbitral award, through an arbitration, the Petro Union case was gotten through a judgment of the Federal High Court and affirmed by the Court of Appeal. But the similarity is that both cases, there's serious fraud involved, or there was serious fraud involved. Both judgments, the arbitral award and the Petro Union judgment at the Federal High Court were both fraudulently obtained. There was serious fraud in the cases. That is the similarity.
Yeah, but I wanted you to identify some of the essential issues and give a background, of what led to this point.
Okay, it's really quite simple, Dr. Abati. The issues are straight, but the legal process is technical. The fraud in the Petroleum Union case is very straight. But I will explain to you at the end what makes it very technical in the process of litigation. It is like this. In 1994, the Petro Union got a check and lodged it in a Union Bank branch in Lagos. The check was purportedly issued by a company in the UK by the name Gaze Aft. Petro Union claimed that they wanted to set up a petrochemical plant, build refineries, and use part of the money to set up a bank in Nigeria. So they presented the check, and of course, because of the volume of the check and because of the fact that the Central Bank of Nigeria monitors and supervises such huge transactions, they couldn't give effect, they couldn't honor that check. So they went to the to the central bank. So the central bank ignored it or waited for further facts, further information, further pressure to give effect to that check. Now, the Petro Union kept mounting pressure on CBN. We want this money, we want this money. This money has been lodged in your account. They claimed that Union Bank collected a part of the money and lodged a bulk of it with the central bank, that they want that money. So after a number of years, Union Bank said, you know what, let's do some background checks. How can we just release us from? Let's find out what really happened, the genesis of all this. So they contacted Barclays Bank in the UK, which purportedly issued that check. We backed that check. Barclays Bank told Union Bank and the Central Bank of Nigeria that on no account must you pay this check because this is fraudulent. This is Barclays Bank explaining. So Barclays Bank told Central Bank what they found. They found out that the company Gaze Aft, which purportedly issued that check of £5.6 billion, was non-existent as at 1994 when Petro Union presented that check. So that raised quite a lot of concerns. Barclays Bank said, in any case, even if the company Gaze-Aft ever existed, as at 1989, that the company had stopped to exist. Barclays Bank went further. Central Bank of Nigeria further confirmed that they went to the company registries in England, which is the equivalence of our CAC, Corporate Affairs Commission. They went to the company to find out, and they found out that such a company doesn't exist on the roll of companies in the United Kingdom. Now, further investigations, revealed that, well, a company, Gaze-Aft, existed, but had closed up as at 1989, September 1989. They had withdrawn all their monies, every penny they had with Barclays Bank, and wound up as a company. But the check they purportedly issued to Petro Union was issued in December 21st, 1994. So the question is, where fraud comes in, is that how can a company which closed shop in 1989, which no longer exists, 6 years after, is still issuing checks? That was why Barclays Bank informed the Central Bank of Nigeria not to give effect to that check. So in this situation, Petro Union got, angry and claimed that there was fraud, that the CBN colluded with Union Bank to defraud them, to deny them access to their 2.5 billion. So they went to EFCC and reported this case. EFCC swung into action, got the managing director of Union Bank to answer to these allegations. The EFCC did a very thorough investigation and found that the managing director of Union Bank, by implication Union Bank, was completely innocent of the allegations. They exculpated them completely and closed the case. They said they didn't have any case to answer. So further being disgruntled, Petro Union at that point went to the Federal High Court to sue the CBN and the Union Bank, That was how they got a judgment. And the judgment was affirmed by the Court of Appeal in 2014, and they were awarded £2.1 million. But the court also further ordered that Union Bank or the CBN, they should be paid, Petroleum Union should be paid that money in addition to 50% interest per annum. That was how the entire judgment sum, as of today, is $15.5 million or 9.6 million pounds. That is where we are. So the case is now at the Supreme Court, and now serious legal issues have come up. The question a lot of people are asking, or why people go worried, is that when they found out that there was fraud, why didn't they raise those issues on trial? The truth of the matter is that Union Bank or CBN didn't know at the time that Gates fact was just not existing or had wound up. It was fresh evidence that came up. Now, legally, the technicality of it, well, as a lawyer, there are certain aspects of the case that I cannot comment on right now because it will be sub judice, but certain things must be noted. Can the Supreme Court admit new evidence at that appellate stage? Many people are not aware of this. Yes, indeed it can. Or rather, can it set aside the judgment of the lower court for such a case? Of course, there are a plethora of judgments where the Supreme Court can, or where an appellate court can indeed set aside a judgment that is fraudulently obtained. In this case, it is clear that it was fraudulently obtained because in its own cases, like alleging Nuruddin Oluwa Tumishe and Labinjo Falana, the Supreme Court enumerated 6 grounds on which a judgment can be set aside that is that was fraudulently obtained. But even in recent cases of the appellate court, like Atuyeye and Ashamu, like Elias and EcoBank, which is a 2016 case, Justice Amina Aogi.
I do hate to interrupt you at this point. We've got to take a short break, and we'll be back with more. You can finish your thoughts then. Please stay with us. Welcome back to the morning show here on Arise News. Still with us is Jude Igbanoi, Deputy Editor of The Lawyer, a weekly publication of this day newspapers. We're talking about the complexities of the Petro Union case. Do continue.
So, like I earlier mentioned, there are plethora of cases where the Supreme Court or the appellate court can admit new evidence or can set aside a judgment of a lower court. There are 6 grounds, like were eloquently enumerated by Justice Amina Aogi of the Court of Appeal, as she then was, who is now in the Supreme Court. In the case of Elias and EcoBank, the grounds are really where the grounds are about 6, but let me mention just a few. 1, when a judgment is fraudulently obtained or obtained with deceit, and when there was a concealment of a vital information relevant to that judgment, or where a court gives a judgment without jurisdiction. When the court lacks jurisdiction and gives a judgment, it can be set aside. Then you remember the innocent case and GTB. But a more recent case, a more pertinent case, is the case of Arik Air and Ekemezie, when there are intrinsic factors and all the other, out of the 6 grounds on which the Supreme Court can admit fresh evidence or set aside the judgment, they were all eloquently enumerated in Arike and Ikemeze. Now, as for the Petroleum Union case, the questions people should ask, a company that wound up in 1989 is issuing checks in 1994. And Union Bank just later found out this. Union Bank, Barclays Bank, and the CBN, because they commissioned a research into the activities of that company and found out that the company had wound up. And the EFCC investigated the managing director of Union Bank and found him completely innocent of the allegations that Petro Union levied against them and all of that. So it is on this basis that many are expecting the Apex Court, the Court of Appeal, to either set the judgment aside or send the case back to a trial court to be tried de novo in light of the new developments, in light of the new findings that...
If I could come in here, there's also an issue with regards to legal representation that has been thrown up. Can you shed some light on that? Who really is the counsel for this matter?
That issue is also very complex. The background is this. Mr. Igbanoi SN was briefed by Petroleum Union to represent it to pursue their case. Igbanoi, seeing the complexity of the case, approached a senior counsel, a senior colleague, Chijeke Gazama SN, to lead him, because it's a normal thing. When a big case, a high-profile case, comes to a lawyer, he will understand the case. He has the ability to prosecute it, but he can approach a senior colleague, please come and lead me in this case, to give weight to the case. So Igbanoi approached Gazama to lead him. So Gazama came in and was leading Igbanoi, but disagreement came up between Igbanoi and Gazama. I think there are some of these things that I cannot discuss on air because both counsel, Gazama is my very close friend, he's a bosom friend. There are some of these things that I just cannot discuss now, but they had disagreement. I think it is in relation to fees. So Igbanoi now applied to court that he wants to debrief Gazama from leading him. But Gazama had taken up that case to lead Igbanoi. So you now ask yourself, logically, is Gazama counsel to Petroleum Union or responsible to Igbanoi? Igbanoi told the court that, look, I am the real counsel. This is a letter briefing me by Petroleum Union. I only asked Gazama to lead me. Now I don't need him again at this point. Gazama said, no, I've appeared at the Court of Appeal. I have appeared in this case. I am the real counsel. So they thought it was a minor issue, but they got to the Supreme Court just yesterday, and they couldn't resolve that. The lead justice of the panel hearing this case, Justice Ariwola, is a very, very diligent, very intelligent person. Okay, gentlemen, I'll give you a few minutes, resolve this issue. This is me speaking. In my opinion, if they had a good case, they would have said, okay, it doesn't matter whether it's Gazama or Igbanoi that is the counsel to Petroleum Union. Let's just go ahead with the case. At the end of the day, if it has to do with fees, we can sort that out. But they refused. Igbanoi insisted that Gazama must not be in the case. Gazama insisted that he's the real counsel. So, as much as Justice Ariwola, a very patient, intelligent justice of the Supreme Court, tried to resolve that little matter, seemingly little matter, between the two counsels, they refused. So the court could not go on. The counsel to the finance minister had announced appearance. The Attorney General of the Federation had announced appearance. Counsel to CBN and all the other parties, to Union Bank, CBN, had all announced their appearance. But they couldn't put their house in order. You can see how Petroleum Union from the onset of the case have had challenges challenges, and which makes the case very bad for them. So the Supreme Court could not hear that case yesterday. So that is the position. But like I pointed out to you, Petroleum Union actually briefed Igbanoi. Gazama was not part of it. Igbanoi approached Gazama, come and lead me. So this is where the confusion arose.
Okay. Thank you so much for taking time to diligently go through all of this. But I'd like to ask, what are the lessons? What is the way forward? Ngozi Okonjo-Iweala talked extensively about this in her book, when she talked about judgment debts. How sorts of people bring all sorts of fraudulent deals, rope Nigeria in, collect money from Nigeria as a country by Nigerians. So it's for us by us, destroying ourselves. And you ask, what's the sense of patriotism in all of this? This is just one you mentioned. There's another one coming up, SunTrust. There's so many judgment debt cases here and there. Which way for Nigeria in all of this?
Now, let me point out that I am worried, like many other Nigerians are. But I want to say emphatically, I don't know if we'll have the time for me to explain some things. Nigeria at this point cannot afford another P and ID judgment at this point. No. You see, there was so much hullabaloo over the 9.6 billion arbitral award by P and ID case. But this one, we are talking about $15.5 billion. You can imagine, and in any case, the damage to the Nigerian economy is going to be so huge that Nigeria may not be able to recover from it for years. Ask yourself, what is the annual national budget of Nigeria? Then look at $15.5 billion. Nigeria just cannot take such a judgment for now. But that is not even the case. The case is that the judgment itself, which they seek to affirm at the Supreme Court, is fraudulent. New revelations have come out that is fraudulent. So it's a question of people trying to reap where they did not sow. That is one. And they take advantage of the weaknesses, the loopholes in the Nigerian judicial system, justice delivery system, to want to obtain all sorts of judgments and effect them in this case. Thank God there's reprieve now from on the P and ID case, and this one is coming up. It will do damage, serious damage to the Nigerian economy if $15.5 billion leaves the Nigerian economy. But something must be pointed out. You keep hearing Union Bank. The fraction of this amount that Union Bank is responsible for, it's very minor. It's, I can say, negligible, about 396,000 pounds. So Union Bank can easily, in the unlikely event that the loser appeal, Union Bank can easily cushion that. It's Nigeria, the CBN, Ministry of Finance, and that will bear the bulk of the judgment in the unlikely event that the Supreme Court affirms that appeal. So the judgment is targeted at the case is targeted at Nigeria. It's Nigeria that will be the huge loser at the end of the day in the unlikely event that they win. This is why. But let me also mention this, because you asked.
About 30 seconds to go, Jude.
Yeah, let me just quickly mention this because you asked. I don't believe in conspiracy theories, but in this case, there's a strong conspiracy theory that I'm hearing, which, in my view, must be seriously addressed by Union Bank. Many people are made to believe something that it's some kind of demarketing for Union Bank by their competitors, because people keep saying, Union Bank has a judgment of $15.5 billion against them and all that. The Union Bank cannot take the heat of, I'm not sure, its entire assets and deposits at the CBN out to $15.5 billion.
Well, on that note,
So-
Jude, on that note, we'd like to thank you very much. We've run out of time. Thank you for joining us on the morning show.